Hi, my name is Kelly Tebow, and I'm with the New Jersey Center for Tourette Syndrome and Associated Disorders. I will be your organizer for this evening and would like to welcome you to our webinar on NJ harassment law, harassment and intimidation and bullying law. Know your rights as a victim and accused. Thank you all for joining us. Before I have my colleague introduce the speaker for tonight, I'm going to cover some housekeeping items with you. All participants are muted. If you have a question, please type it in the bottom of your question box and click send. You may send as many questions during the webinar. However, we will have Ms. Manes answer the questions at the end of her presentation. We will get to as many queries as time allows. In addition, tonight's presenter is available to take your questions on the Wednesday webinar blog, which is accessed from our homepage under the heading Programs. This blog will be monitored for the next 7 days. Feel free to look and post questions as often as you like. Answers will be archived for future reference. If you missed part of the presentation or would like to watch it again, an archived version will be posted to the website. We value your input, and in order to expand the webinar experience in the future, we need everyone to fill the survey out as you exit the webinar. The NJ Center for Tourette Syndrome and Associated Disorders, its directors and employees assume no responsibility for the accuracy, completeness, objectivity, or usefulness of the information presented on our site. We do not endorse any recommendation or opinion made by any member or physician, nor do we advocate for any treatment. You are responsible for your own medical decisions. Now I'm going to turn over the introductions of our speaker to Martha Butterfield, the webinar coordinator of NJCTS. Marty?
Thanks, Kelly. Good evening, everyone, and welcome to tonight's webinar. Before I introduce our presenter, I would like to remind those of you in New Jersey that we will once again have a booth at the annual Teachers Convention in Atlantic City. You'll find us at booth 1209, so please stop by, say hello, ask questions, and find out what's new in the arena of programs and services for families living with Tourette syndrome. Not only is October National Bullying Prevention Month, it's also about 6 weeks since school started for most kids, and often the time when bullying issues present themselves. We thought it was a perfect time to bring the issues of bullying to the forefront of our webinar schedule and have someone cover the topic thoroughly. So to that end, we have invited attorney Beth Manes as an expert in the field of special needs advocacy to bring you up to date with the current state and federal bullying statutes. I think this quote from Beth's website beautifully captures her thoughts about advocacy for those with special needs. There's nothing I love more than helping a family go from feelings of despair and guilt to feelings of relief and optimism, knowing that everything is in place and they can relax and enjoy time with their family. Beth earned her BA cum laude in politics with a minor in Spanish and her law degree from the University of Michigan. Her practice concentrates in special education law, special needs planning, guardianships, and estate planning. Beth, welcome to our Wednesday webinar programming. And now, without further introduction, I'm delighted to turn tonight's webinar over to you.
Okay, thank you. I'm not seeing the webinar slides. Is somebody else seeing them? Do you see the webinar slides? Because they disappeared from my screen. Anyone? I have a printout.
Sorry, we both were muted. No, we're not. You hit the little yellow star or your PowerPoint in your system tray.
That's where I was. All right. Are we, oh wait, sorry. Okay, there we go.
Yep.
Okay. All right. Sorry about that. Or just to add to everybody else's disclaimers, this webinar, this presentation is informational. It's just for our discussion purposes, just to give you some information. Nothing herein should be construed as legal advice. Okay. Disclaimers out of the way. I want to provide just a little bit of history about why we have the Anti-Bullying Bill of Rights Act. You know, when we were kids, kids were mean, and that's just the way it was. But enough studying has been done more recently so that our children are a little bit better protected than we were. And they found, you know, the incidence of bullying is skyrocketing. It's whether it's due to the internet, and I'll talk about that a little bit more later, or just kids are more creative. I don't know, but given the increase in bullying and the increase in just the harm to the kids and the people realizing the detriment it was doing to the children, we now have an Anti-Bullying Bill of Rights Act, which has been was amended in 2012 and again in 2008. And also, I should add to my disclaimers, I'm only licensed in New Jersey. I only practice in New Jersey. I will be speaking, you know, mostly about New Jersey law. Each state has their own versions of these laws, and if you're in another state and you have questions, I can answer them generally, but would direct you to an attorney in your own jurisdiction. So again, the New Jersey law in 2018 was most recently amended, and throughout the slides I've highlighted in purple, and I'll note them for you specifically, you know, where we've got some new legislation protecting our kids. In one of the 2012 ones, oh no, help. Okay, sorry. One of the 2012 amendments, we have an anti-bullying task force, which is supposed to, I guess, really help add some uniformity to the rules in New Jersey so that when you go from district to district, everything's treated similarly, and that from the highest level down, we all know what's going on and how the rules are being applied. You often hear, you know, our district has a zero tolerance for bullying. Well, you know, what does that really mean? You know, it's supposed to mean that, well, we'll impose a punishment for every infraction, but that doesn't take away the obligation for a district to investigate things, because, you know, not only do the children who get harmed have rights, so do the children who allegedly did the harming. So an investigation still has to be done, and you know, not every infraction will result in punishment to the person who did the harm, because other factors get considered, and we'll get to those as we move along. So again, we talked about it. It's not really bullying, it's HIB. And what does HIB stand for? It's harassment, intimidation, or bullying. So we've got, you know, a statutory definition now, and everybody's got a little bit more guidance on what it is you can and can't do. It doesn't have to be verbal, it doesn't have to be physical, it can be written, and it can be, and I've got it underlined because it's really important these days, electronic communication. And we'll talk about that a lot. Well, I'll talk about that a lot as we go on. It doesn't have to be constant, you know, just because somebody does something only once doesn't mean that it doesn't rise to the level of harassment, intimidation, or bullying. One of the big things to remember is that it's not just kids being mean, it's kids being mean because of something specific about the victim. It's an actual or a perceived characteristic. You know, generally we follow the same, it's sort of the same things that would rise to the level of discrimination. You know, if it's race, color, or religion, you've got national origin, sexual orientation, any disabilities, something that a reasonable person should know, that if you pick on somebody for that specific characteristic, it's going to emotionally hurt that student. Now, HIB doesn't take place only in school. You know, of course it does take place in school, but kids aren't immune to the repercussions of HIB if something happens at a school-sponsored event, off school property, on the school bus, or even walking to the library, or at a football game, or even in the mall. As long as it's determined that whatever is being done is substantially disrupting or interfering with the orderly operation of the school day and the rights of other students. You know, whether it's something that is specifically harming to a person or a person's property, or puts them in reasonable fear. You know, if somebody threatens you, you know, I'm going to do this to you, or I'm going to do this to your stuff, I'm going to key your car, I'm going to dump your locker. You know, if somebody reasonably believes they're going to be harmed, that can rise to the level of HIB. Whatever the person is saying to the victim will have the effect of, you know, insulting them or demeaning them. Maybe they're just creating a hostile environment. You know, I can't walk down this hallway because I'm going to pass this kid's locker when he's there at lunchtime, and I know I'm going to get picked on, or some insult is going to get hurled at me. So there are certain places I feel like I can't go. And it's causing me emotional harm. That rises to the level of HIB. So we've got a new regulation, which I really, really, really like a lot, because there's always the one thing that you just couldn't, for some reason, we couldn't put a label on, and we finally have, and it's the power imbalance. That now every board has to have a policy that includes a statement that there's a power imbalance. That, for example, there's always like the popular kid, the unpopular kid, and it's either real or a perceived power imbalance. So, perceived power imbalance is, you've got the football captain and the kid who just goes to the robotics club meetings. You've got your social cliques. You know who the cool kids are, and you know who the cool kids aren't. So you've got that power imbalance because you've got the middle school social structure. And then there's an actual power imbalance. Excuse me. You've got a teacher and a student. That's a real power imbalance, and actions by a teacher can be conceived and can be considered HIB. And because of that, we have another regulation which prohibits a member from the same bargaining unit from investigating a claim against a fellow member. So if you're accusing a teacher of harassing, intimidating, or bullying your child, part of the investigative team cannot be somebody from that teacher's same bargaining unit. So that protects the student as well. Now, bullying, we also have to consider the, are things direct? Are they indirect? Again, I always think back to when I look at the cases that come in my office, I'm always like, I lay those scenarios over things I remember from my childhood. And most of the things I remember were more direct, people getting hit or, name calling. Of course, we never had any of the texting or the online things. The ways that people can be mean to each other now are just, it's unbelievable. But it's the indirect stuff that you could never really complain about because it was so much harder to prove. You knew your friends were doing something without you on a Saturday, but what could you do about it? Well, now I know, my kids know if their friends are doing things without them, because guess what? There are pictures all over social media, Instagram and Facebook and Snapchat and whatever, people spreading rumors, texting others, and again, it was a lot harder to prove 30 years ago than it is now, because for some reason, the kids just aren't smart enough not to put it in writing. When you remember the game of telephone where you would tell somebody who would then tell somebody, or the Breck commercial, depending on how far back you want to go. But now kids don't tell somebody, they text somebody, and then that gets screenshotted and everybody finds out. And so, there's much less, although it's indirect, somebody's always dumb enough to memorialize it in a text message. Which leads me to cyberbullying, which is huge. I mean, most of the bullying we see in our office is somehow cyber related. And it takes place everywhere because they only communicate online now. Whether it's their email and text messages and the social media. I cannot keep up with the social media and the ways that these kids have found to be mean to each other. It's almost like the law is trying to keep up with the creativity of the meanness of the kids. I've got a graph from a few years ago. I cannot find an updated graph of this, but you can see this was from, I think, 2 years ago, where the apps that were used for cyberbullying, that 71% were Facebook. I showed this to my kids. The kids in my house are between the ages of 18 and 28. And the oldest one, agrees that, yeah, it was probably Facebook back when she was in high school. The youngest, who's 18, said nobody uses Facebook. That's for old people. So I'm sure this has changed some, but again, like there are always new apps. They're always finding new ways. So, what's a school to do? All right, so a school can adopt a policy. Okay, it prohibits HIB. Okay. And then what are they going to do with it? Well, they have to respond promptly. The go-to person in a school is the school principal. And the principal's got a day to start an investigation. And this whole investigation cannot take longer than 10 days. And once they have an investigative report, that has to go to the superintendent, who may or may not take action. And then ultimately it goes to the Board of Education, and it says specifically no later than the next Board of Education meeting. Now, some boards of ed don't meet more than once a month. You know, some meet every week. So somewhere between a week and three to 4 weeks from now, you know, it'll be ultimately decided by the Board of Education what's going to happen. So the Board of Education has to either affirm or deny the superintendent's recommendation. So people often think that the Board of Education is just a rubber stamp for the superintendent, and I might be one of those people on occasion, but you know, I've seen enough of these that I do believe the Board of Education reviews the investigative reports and makes a decision. But again, they only have the information that's put in front of them. And although you can appeal a decision from the Board of Education, you won't succeed unless you can establish that the Board of Education acted in an arbitrary, capricious, or unreasonable manner. And that's a pretty high standard to meet. One of the things that we have a new regulation for in terms of, it's not even so much how the board acted, it's even before we get to the board, that the board is allowed to create a policy that says that the principal, in working with the anti-bullying specialist, can decide whether or not to investigate at all. You know, when this HIB law was first passed and everybody was complaining about, harassment, intimidation, bullying, everybody was getting picked on and reports were getting filed all the time, and they had to investigate everything. And many of them really were unfounded. People were using this law as a way to pick on each other. It was, sort of harassment, intimidation, and bullying through harassment, intimidation, and bullying. So now local boards of education are allowed to empower the principal to say, okay, I'm looking at all the facts in front of me. If everything you're saying is true, does this rise to the level of HIB? And if the principal decides that even if everything is true, if I investigate and find that, yes, this person said or did this, it still doesn't rise to the level of HIB, then the principal doesn't even have to investigate. And a parent does have the opportunity to appeal that decision. Once the investigative team is done and they finish their report, they have to provide results to everybody involved. Whether you are the accused, the accuser, you get information, you know who was spoken to, what was decided, if discipline was imposed, if any other action was taken, basically what was the superintendent's recommendation. And then everybody still has rights to keep going, whether it's the parents of the accused or the parents of the victim, you can always appeal the decision that was made. Excuse me. So if you are requesting a hearing before the board, say you don't like the decision, that has to be held within 10 days of your request. And you should know that's held in executive session. I don't know if many of you have probably been to Board of Ed meetings, but there's always the public portion and there's always the executive session where you never know what's going on. And, when they talk about the students, oftentimes they'll use numbers instead of names. So everybody's privacy is protected. So these hearings, if you're ever considering appealing something to the Board of Education, but you are worried about your privacy, the hearings are held in private, though I've never seen it where, somebody sort of ushered in through the back. People know you're there, but they won't know what was said and what happens. One of the new regulations we have gives a time frame for how long you have to request a hearing before the Board of Ed. Before, there was sort of no time frame, and you kind of had forever, which wasn't really practical. Now you've got 60 days after you receive the written notice of the outcome of the investigation. So if you hear, through the grapevine, oh, they didn't find HIB, until you receive written notice of it, the clock doesn't start ticking, because at least then you know exactly what it is that you're appealing. If you're appealing a Board of Ed decision, now you're going to the Commissioner of Education. And the Commissioner of Education has to find that the board acted in bad faith. There was utter disregard for the circumstances, or they violated legislative policies. It's going to be, the higher up you go, the harder it is to get a decision overturned. Just to give you an example of what happened, a case that didn't go the way maybe the parents thought it was going to go. Something up in the township of Jefferson, and it was a question of, was this child a victim of HIB, under the law and the definition of the law. So basically, this young girl, I think she was 13, was in a group text it was off grounds. I think there were five girls in total. There was a group chat. I censored the language for the purpose of the slide. I'm not going to, I will assume the asterisks are there when I'm reading it too, but something negative was said, presumably about her race. And she was a student of color, and the student who sent the text was not. So the next day, this was a Friday, the next day on Saturday, her mother notified the principal and the superintendent and her teacher, sent them an email, told them what happened. Monday, which was the first day of school after that, the principal let her parents know that he started an HIB investigation. A few days later, the principal notified the parents that there was no evidence that she was the target of an active HIB. Now, reading the language of the text, this is one of those where there's information we just don't have, but it was found that she was not the victim of HIB. So the petitioner appealed to the board, who denied their request to overturn the determination. They then went to the Commissioner of Education, who found that the students were engaged in ordinary student conflict, that the child didn't suffer any detriment, and she voluntarily participated in the group text, and the board did not act in an arbitrary or capricious or unreasonable manner. And again, I know there's more. I wish I could tell you what it was, but they're definitely, the reason they found that it was just ordinary student conflict. So let's talk about what that is. Bullying tends to be one-sided. Somebody says something to me, I don't say anything back. Whatever was said to me was intended to hurt me. You're picking on my size, my color, my ability or disability. There's that imbalance of power. Usually it's done in private, not out in the open, because bullies are generally cowards and don't want to do anything where somebody might call them out on it or, God forbid, protect me. So, it's going to happen again in private. And it's so easy to do now because, again, they've got cell phones and they just text mean things to each other. Ordinary student conflict, mutually competitive. You got, two 13-year-old boys hurling insults at each other on the playground. It will often turn to, inappropriate things about, race, religion, political leans. These days we see a lot of that. Whatever, color of your hair, sexual orientation. But if it's deemed that they are sort of equal power and they are yelling things back and forth to each other, it was just sort of a disagreement. It wasn't one person picking on another. They're doing it out in the open. It doesn't happen all the time. That's going to be deemed just ordinary student conflict. All right, I mentioned before the anti-bullying specialist and that they do an investigation. So what does this investigation look like? They have to interview everybody separately. If you've got 5 people around a table, one of them was the victim, 4 of them are the witnesses. They're not interviewing all 4 witnesses together. They're certainly not interviewing the victim with the accused or any of the witnesses. Ideally, they'll have them write written statements. That way they don't really have time to check their stories with each other. On the other hand, when there's a written statement, I like the student to be able to read it over. Maybe they remember something. It depends on the age of the student. It depends on the type of conflict. They have to document everything. When and where did it happen? Was this the first time it happened? Is there a frequency of complaints from student A about student B? Have they tried anything to intervene in the past? Do we need a safety plan? And if there is, we need to implement one. For example, we've got a kid, we got the district to put some cameras in the hallways. We had, if somebody's feeling threatened, sometimes the school, thinking they're being nice, just to throw the parents a bone, they'll say, well, here, we'll give your child an aide to walk with them through the school. I'm like, well, that certainly doesn't make them stand out anymore. So I don't like the victim to have the bodyguard. I would rather the bully be the one to be separated from everybody else, and maybe not necessarily to stand out from everybody else, but if they have to be separated, I don't think it's the victim who should have to eat lunch by him or herself in the hall or in the nurse's office. Maybe it's the bully who doesn't go out on the playground after lunch if he or she can't learn to play nice with everybody else. But there are all sorts of things you can do to make a student feel safer, whether it's another adult in the room, or on the playground, or cameras in the hallways, because you know when I turn this corner, you know, so-and-so is going to come after me, for example. The anti-bullying coordinator, again, appointed by the superintendent. These are all the duties of an anti-bullying coordinator and all of the things they have to do with the principal and the anti-bullying specialists, let the board know what's going on in the school, you know, based on what they see on the ground, what can we do to strengthen the district's policies, you know, to sort of see what's going on, address it sooner, and maybe prevent these acts from occurring. I think one of their most important jobs is to provide this data later to the State Department of Education. The new thing, and that's why the word climate is in purple, is there's now, it used to be a school safety team, now it's the school safety/climate team, which is chaired by the anti-bullying specialist. And the goal of this team is to figure out what's the environment like. You know, has our school become a hotbed of anti-Semitism? Is everybody picking on, you know, the students of color? You know, the population in our district maybe has changed, and everybody's, you know, picking, again, as I said, students of color. You know, we've seen a shift in the last couple of years. I'm not kidding. In middle schools, people having, not people, kids having fights over political affiliations. So we added climate teams, so that climate to the team, so that they can get a sense of, you know, what's the environment like in our school, and what can we do to change that. You know, maybe we need some sensitivity training, maybe we need some diversity training, you know, whatever it is that they think can address it. This team adds that. I think it's a valuable addition to the school. It also clarifies that the provision that added this, it clarifies that parents aren't supposed to receive confidential student information that other people on this team are not supposed to receive. Okay, this one, another new regulation that this is kind of key, because you don't want, although the parents are all allowed to have information about the investigation, you have to be careful how much you're relaying. You know, for example, and this is a tough one, if your kid was picking on somebody else, you're entitled to know the results of the investigation. Well, are you entitled to know that your child was picking on somebody else for being gay? You know, maybe that student is still in the closet and doesn't want anybody else to know that he or she is gay, and that's what led to this. Are you entitled to know this? You know, whose rights trump whose? Because the child has a right to privacy as well. So it's putting districts sort of in a difficult situation, but I feel for them on some level. On the other hand, I think it's important that, you know, our state legislators realize that this is a potential problem. Okay, so when the report comes out, what do you get? You get a description of the allegations. You get a list of who was interviewed. You know, you can read what you get, summary of witness statements, all the documents they looked at, but so list of individuals. Do you really get a list of all the students and what they said, or do you get a bunch of redacted names with what they said? You know, oftentimes they're going to protect the privacy of everybody because maybe one of the witnesses doesn't want to be identified. You know, and again, the districts are straddling the, you know, everybody's got privacy rights, and whose privacy rights trump whose. Okay, now we also have new regulations that pertain to the approved private schools for students with disabilities. In New Jersey, we have a list of approved schools for out-of-district placements where students with disabilities may go. And until recently, 2018, it wasn't really clear what their obligation was with respect to HIB. So now we have a regulation that says that you know, they have to adopt their own HIB policies, and we have a little more guidance on what happens, you know, if there's something on school grounds, or on homeschool grounds, or on approved private school grounds, or on the bus from one to the other. You know, who's in charge? You know, who's holding that bag? So the sending board, you know, your homeschool, will take the lead if something happens on their school bus at one of their school sponsored functions, or off school grounds. If it happens in the approved private school, that's when the approved private school is in charge of the investigation. Regardless, the approved private school needs to cooperate with the sending district in the investigation if the sending district is doing the investigating. All right, we should talk a little bit about law enforcement, because sometimes law enforcement does have to be involved. There are some mandatory referrals. For example, if there are drugs or firearms involved, if somebody's threatening your life or serious bodily injury, or if there's criminal sexual conduct or contact, then the school must refer to law enforcement. Also, bias intimidation. If something's motivated by, race, color, religion, you can read the list. As long as there's an underlying criminal act, then also that gets referred to law enforcement. Hazing. I put it in because it's part of the law. I've never seen it. Hazing is something you think of, with your college kids or pledging fraternities and sororities. I know there are some schools that have either high school chapters of Greek organizations or other types of clubs and organizations that do haze. Again, I've never experienced it. I haven't seen it in New Jersey recently, but I imagine it happens often enough that we've kept it as part of the law. So just know that it's there. And cyber harassment, that, the law enforcement gets involved with cyber harassment. So again, as I explained, I do see a lot of this. And again, you're communicating with somebody electronically with the intent to harass them. Kids are very bold when they are hiding behind their screens, and it's just, I'm sure you all tell your kids, unless you would say it to somebody's face, don't put it in a text message, don't put it in an email. Imagine that you've written it on a piece of paper and handed it to them, because that's ostensibly what you're doing once you put it on somebody's screen that they can screenshot and take with them elsewhere. Another big one, sexting. This could be an entire seminar on its own. Excuse me. It makes sense to us as adults that you should not send explicit photos of yourself by electronic means, yet our children don't seem to understand that. We've even seen a kid, a 12-year-old girl, sent a picture of herself to somebody, and lo and behold, was so shocked and amazed to find that other people had seen that picture. Who'd have thunk it? And then, to make matters worse, it got far enough that law enforcement was involved because it was a naked picture of somebody under the age of 18. So she found herself faced with child pornography charges. So I couldn't wait to get home that night and tell that story around the dining room table, because sometimes I fear that our children just don't understand the ramifications of the things they're doing. So if you take nothing else from this webinar, please go home and tell your children that story, and that they really should, unless you would do it in public, don't put it on your phone. Okay, let's talk discipline, because ultimately when you are bullying somebody or somehow otherwise violating a code of conduct, you will be disciplined. So every district has a code of conduct which tells the students how they must behave, what you can and can't do, and if you violate this code of conduct, bad things will happen to you. So the bad things I'm going to talk about are just suspension and expulsion, mostly because nobody's coming to a lawyer for a garden variety detention. Rarely is somebody coming to me for a garden variety detention. Now, suspension and expulsion, they've done studies and they found that it disproportionately affects students, students of color, students in lower socioeconomic groups. I would add to that, though I haven't seen a study that says it, just anecdotally, I would add to that students with disabilities, because often the disabilities go underrepresented or underidentified, and we'll talk about that in a few more slides. I'll talk about it some more. But you're talking about kids who are otherwise at risk, and now they're missing school days and they're missing teacher lessons and they're not interacting with their peers. If they've got a good role model in school, now they've lost days with that good role model. As the kids are older, missing a couple of days of AP classes is a big deal. And don't think that the AP kids aren't getting suspended or expelled, because they are. One of the other things that the study found was the financial burden on the government because of the suspension hearings and services. I don't really care so much about the financial burden on the government. I think they're just not, they need to be handling our kids a little bit better. We try to push for more creative solutions, because when these kids are acting poorly, there's usually a reason. why are they behaving this way? They're not, you always hear the kids aren't inherently bad. I really believe kids are not inherently bad. They do dumb things, they do bad things. But generally we can teach them and we can explain to them. And, we had one, just to give you an example, where a student did a really dumb thing, and it was a cyber thing, and he sent a picture he shouldn't have sent, and bad things happened, and the police were involved. And ultimately what we worked out with the district was, yes, suspend him as you must, and they did what they had to do, but we also worked in some training on, cyber harassment training and bullying training and a little sensitivity training. I can imagine a situation where we would do some, maybe diversity training. And there are all sorts of things you can do to make students aware, not only what they did was wrong, but how it affects the people to whom they did it. And so what we worked out was, we're going to do that. And if a year from now he hasn't done anything else bad, they would wipe the slate clean and take the suspension off his record, because he wanted to go to college. He is probably next year applying to college and should be able to go with a clean slate, having learned a really bad lesson, because you can really, really ruin the trajectory of a kid's life. And I'm not saying children shouldn't have to face consequences. They absolutely should. But, we're sort of, with these young people, we're at a point here where we can help them and direct them and mold them and really fix the trajectory they're on. And, if this kid weren't allowed to go to college because of this one dumb thing he did, it would just, it really would be a travesty. So we, fell on the mercy of the Board of Education, and ultimately, things went better. So again, we try to be creative here, and we're just trying to help kids. So a little bit about short-term, we've got short-term suspensions and long-term suspensions. Up to 10 days, it's short-term. You've got to they have to tell you, why, you have due process rights. Why are you being suspended? What did you do? What should you have done? What are we charging you with? You get your informal hearing. It can be the same day. And if you're out for more than 5 days, they have to provide academic instruction to you. It's often called home instruction, but sometimes it won't take place in the home. If having it take place, at the public library is often what's done. Again, and also you can appeal decisions of, short-term suspensions, also long-term suspensions. Okay, long-term suspension is when you're going longer than 10 days. Again, the parent has to be notified prior to the suspension. You get your informal hearing prior to the suspension. Within 2 days of 2 school days, rather, so it could be Friday and Monday, of the initial suspension, of the initiation of the suspension, the parents get written notice. And it has all the components I mentioned earlier of the short-term suspension, with the added bonus of they can tell you that if you do anything else that would warrant expulsion, then you should know that you are voluntarily waiving your right to a free and appropriate public education if they decide to expel you. So you're really on a short leash. And then they also tell you you have the right to an attorney. This is where I come in. So you're entitled to a formal hearing before the Board of Ed. The student is given the opportunity to confront and cross-examine the witness if there's a question of fact. And I bolded and purpled that because it's important. And I think it's a step that people often don't realize can be taken. And procedurally, you can often overturn something because a witness isn't willing to come forward. And if you represent the witness, if you are the witness or represent the witness, you can talk about creative ways to be able to present yourself and also protect the right of the accused to confront and cross-examine you. So it's kind of, again, it's a delicate balance. You can be heard, you get heard within 30 days, and then they've got 5 days, excuse me, to give you a decision. Okay, so special education students and discipline. Special education students are afforded some extra protections, as they should be. You've got the Individuals with Disabilities Education Act. This is a federal law which entitles students to a free, appropriate public education in the least restrictive environment. And the New Jersey version of that is our Special Education Code. It's an administrative law code. Now, these two are the laws that give you an IEP. The Americans with Disabilities Act and Section 504 of the Rehabilitation Act, those are about giving you access to your education. So think the first two, give you, you know, like occupational therapy, Orton Gillingham for reading, whereas the ADA in Section 504 give you extra time to take a test or a ramp so that, you know, you can more easily access the building. Now, I just have to read this first part out loud because this is actually what the law says. Other than preschool students. Okay, so first of all, who would have even thought that preschool students could be suspended? Though I tell you, I guess it is possible because we had a student in kindergarten who was suspended for misbehaving. And what kindergartner doesn't misbehave? But alas, it happened. So we know, okay, preschool, you can't misbehave. You can misbehave, but not once you hit kindergarten. So you can, if they suspend a student with disabilities, they can suspend you for up to 10 consecutive or cumulative. And this is bolded because you have to be careful. A school will suspend for a day here, 2 days there, until they get to 9. And then they get creative with, you know, like detentions or alternate placements within the school, which they don't look at as a change in placement, but we do. So if it's more than 10 days, then they need to let you know that, okay, it's a change in placement. So, excuse me. They can't remove you for more than 45 days unless, of course, you know, there are drugs, guns, other types of weapons. You're inflicting personal bodily injury on somebody else. If you are a student who's receiving special education or related services and you're placed either on home instruction or in an alternate placement, your IEP stays in place and you're still entitled to instruction. So it's important to know that. But before a student is removed for more than 10 days, there has to be a manifestation determination hearing. Now, this means that the school has to look at everything, all the circumstances surrounding what happened, and determine, was that action that's giving rise to the suspension a manifestation of the student's disability? So if they find that it is, they have to do a functional behavioral assessment. You hear the alphabet thrown around a lot. It's an FBA. And then they determine whether to implement or review if you already have a BIP, a behavioral intervention plan. And then they have to immediately return you back to your placement. Unless, of course, the parents and the school together decide maybe an alternate placement is better. And that's sometimes the case. You know, maybe this isn't the first time it's happened. Maybe there are triggers in the building that we just can't remove. And, you know, maybe the student really would be better off someplace else. So who attends this meeting? The people you might expect, you know, somebody from the school district, the parents, relevant members of the IEP team. So, you know, probably the providers of special education and related services. I will bring, if I can, if there's a mental health issue, the student's treating mental health professional, or have him or her available by phone. Certainly I'll have something in writing that I'll want to provide ahead of time because I want everybody to know where I'm coming from. I want everybody to know why I think this is a manifestation of the disability and should be treated as such. So I don't like to pull things, you know, out of my hat or out of my sleeve while I'm at the meeting because I want everybody going in with all the information that I have. So then they will make the determination and, you know, you'll go from there. So just to give you an idea of how this has played out in the past, there was a case where the court had to decide, did a board correctly determine that a student's conduct was not a manifestation of his disability? So what did this kid do? Well, first of all, his disability, he was classified OHI, other health impaired. He had ADHD, which is attention deficit hyperactivity disorder, and he received special education and related services. He was accused of vaping, and he consented to a search of his car where they found not just vape items, but they found a knife in his car. He said, well, the knife is there. I have a part-time landscaping business, left it in the car, didn't realize it was there. Sorry. And they said, oh, well, too bad. It's a weapon and we're putting you on home instruction for up to 45 days. So they had a manifestation determination hearing. It was found that it was not a manifestation of his disability. He was given home instruction, some counseling. They had a disciplinary hearing and he was suspended for the rest of the school year. Parents appealed it, obviously, and it was found that because he has ADHD, he has trouble focusing, and therefore he forgot and left, you know, that combined with a lot of stress he had at home, he forgot that his knife was in the car, he forgot to take it out of the car, Therefore, his action was a manifestation of his disability. So again, just to review, you can appeal pretty much anything, discipline decisions, placement decisions, manifestation determinations, anything, any decision you don't like, you can appeal. But I will give you the warning that a judge once gave us. We were talking to an administrative law judge at a conference once about the flurry of HIB activity, and whether we thought boards of education were deciding them properly or not, and whether it was really worth the parents' time and money and emotional effort to appeal them. And she said, just remember, if it comes to me and I decide against you, now you have a written decision that your child is a bully. And I went, oh, that's an interesting point. So it is something to consider. It's certainly worth talking about. Again, I would work as hard as you can to come up with maybe a creative solution to things. I did talk faster than I promised I would. I apologize for that, but that does leave us with a little extra time for questions, I suppose. I put some resources at the end. Rights Law is a great resource for anything special education. The link I put in is to their HIB stuff, but their site is just a wealth of information. And stopbullying.gov has a lot of good information as well. So I think now we can take some questions.
Okay, thank you. You did talk a little fast there.
I know, sorry.
That's okay. Oh, you had a lot of stuff to cover there. Okay. All right. So we have a question about what happens after a punishment has been determined. So does the school have to announce or make public whatever the punishment is if a bully is found guilty? Or for that matter, I would say either way, whether they're found guilty or not. Does that become public information in the school, or does that just get distributed to the families involved?
No, it just goes to the families involved. And it's not public. Everybody's privacy is supposed to be protected. If it's something that's discussed at a board meeting and there are always notes taken, or even recordings of it, they usually use numbers to refer to students rather than names. Sometimes they'll use initials. I might object to them using initials because, especially in a small school district, or if everybody knows what's going on, everybody knows who MK is. So I want you to just use a number.
Yeah, but so I just want to take this a step further. So it seems to me that wouldn't it be a process to make it public in some way, because as a deterrent, this is what happens to you when you do that? Or conversely, this is what happens when you claim it and it's not true.
I don't know that it necessarily has that effect. I don't think our kids understand that. I don't think they get the repercussions. I don't know that it has that effect, the deterrent effect. And I think the danger in revealing too much privacy outweighs the potential deterrent effect. I mean, look, there's a grapevine facilitated by cell phones, so I can't imagine people don't always find out anyway. But I don't think it's for the school district to publicize.
Okay. All right. Fair enough. It was just, I saw it as the possibility that it would make people more aware of it. So is the manifestation meeting for a student with an IEP different than a student with a 504?
No, it shouldn't be. And actually, what I didn't say, and maybe somebody will ask this, or should I just answer a question that I'm anticipating? I don't know.
Go ahead. No, go ahead. That's all right.
It's the same whether a student has an IEP or a 504. We've also seen it come in where a student has neither, but does have a disability. So, sometimes there's an issue of, well, wait a minute, you haven't yet identified my child, or maybe none of us saw the warning signs and now my kid has hit rock bottom. Guess what? My kid does have a disability and now needs to be treated as such.
All right. I'm not sure I quite understood that. Could you say that again?
Sure. Just as an example, we once had a student who acted, we believed, impulsively. The district said, he just violated the code of conduct, and we talked about it some more. The kid had been seeing a therapist, so we talked to the therapist, and I'm like, do you think he's got ADHD? And she's like, I really do. I've been toying with that. I think so. So we talked about it some more, and ultimately she did evaluate him, found he did have ADHD, and his action was a manifestation of his lack of impulse control. So although at the time he had not yet been identified as a student with a disability, now
Okay.
we've identified him, and you need to treat him as such. You need to do an FBA. We need to do a behavior intervention plan, and you need to treat him as you would if you had identified him sooner.
Okay, so if you knew up front, now you have to. Okay, I understand now. So does the result of an HIB report become part of a student's permanent record?
That's a good question. Permanent record is vague, and usually people ask that question because they want to know, are colleges going to know that this is what happened?
Yes.
Or if my student transfers to a private school, because sometimes we'll work with a school and we'll say, look, the parents are going to put him in a private school, just let us get through the rest of the school year, but we don't want the discipline records to go. And actually, this is what gave birth to my creative solution of, hey, if he keeps his nose clean for a year, can we pull the suspension from his record? Because I don't want colleges to know. And not all colleges ask for disciplinary records. Colleges are all different in what information they want. So it could be, which is why we work really hard to, clean the record if we can.
Okay. Are there any statistics on the reoccurrence of bullying by either the victim or the aggressor? By someone is constantly a victim, for example, in elementary school and middle, like that person has a kind of a track record, if you will, or
Right.
the fact that a particular student is a bully right through the process?
I don't know what the numbers are, but at least anecdotally, I can tell you that the kid who gets picked on all the time will go one of two ways. Will either become the bully when he or she becomes bigger and stronger and feels a sense of empowerment later on, or will become one of our mental health clients who starts exhibiting signs of self-harm or, God forbid, suicide attempts. And this time of year, you mentioned the uptick in HIB complaints. We've seen a lot of self-harm and suicide attempts in our office. It's heartbreaking. And when you meet with the parents and you talk to the kids, often they were picked on a lot when they were younger, and the school didn't do anything about it.
Okay. This question relates to a particular school district, but so they're saying that they understand that in their district, I'm assuming this is the administration in the district, are releasing personal information when it comes to a threat to others. Do you see any possible consequences for that happening?
If I understand the question correctly, I do, but I'm not sure. If the question is, I don't know if that person can type a little more information, but if the question is, like, let's say my kid threatens to blow up the building and the district says we're on lockdown because John Smith threatened to blow up the building, yes, I think that's problematic.
For John Smith to be outed, sort of.
Yes, I think
but if he's somebody in the school already, now if it were an individual from the outside, that would be different. But you're saying it's problematic then if it's someone who's in the school.
I mean, even if it's somebody from outside the school, I can't imagine that they would have positively identified somebody while they're still on lockdown. And I don't think they're going to identify anybody until the authorities have identified somebody. I don't think it's for the school to do. I think the school's job is to protect the kids.
Okay, fair enough. Do HIB situations occur more with boys or girls?
Yes.
Okay.
I think middle school, it's more, this is just anecdotally. Middle school, it's more girls. High school appears to be more boys. Middle school, we see, um, I'm thinking harder now about who we have currently. I think I'm changing my answer. I think it's more boys.
Okay.
I think it's more boys.
Just because boys just are, more aggressive overall, you think?
But girls are meaner at that age. So that, like, in my own head, that doesn't necessarily make sense, but I envisioning the cases we've had at least over the last year, and it's been more boys as bullies and girls as victims.
Okay. Let me see what else I have here. Do you see incidences of HIB issues any difference between, as different between private and public schools, or is that kind of an across-the-board situation?
It's definitely an across-the-board situation. I think the type of bullying might be different, but kids are kids and kids are mean.
That's true enough, yes. Is there any specific time frame by when an HIB report has to be filed after an incident?
No, sooner is better. While facts are still fresh in everybody's minds. Something I didn't mention is that if a kid goes to a guidance counselor and says this happened, so-and-so, did this to me, sent these text messages about me, the guidance counselor then has an obligation to initiate an HIB investigation. If any school district personnel has reason to believe that an active HIB has occurred, the district has an obligation to initiate an HIB complaint.
Okay. What are the repercussions, if any, for false claims?
Yeah, there is law that says that a false claim is in itself an active HIB, and I have tried to file those. They've never gone anywhere, but the law does provide for that. And again, the ones I filed, it's only been a one-time occurrence. Maybe if it happened more often, they would care, but sometimes kids feel like, well, you filed an HIB against me, well, I'm going to file one against you. So I take that and I said, well, that in and of itself is an active HIB. But I have not yet had one of those pan out. But it can, and I think someday it will. It just hasn't for me.
Okay. Okay. Does the type of harassment HIB differ between boys and girls, such as do girls tend to perpetuate more social exclusion versus boys?
Yes. Yes, it's the boys it'll be more physical. We've seen the cyberbullying is more with the girls, the physical is more with the boys. Yeah, that's been, I think, the main difference.
Okay. I'm getting questions fast and furious here, so just give me a second.
Sure.
Let's see. I'm sorry, I just totally, oh, here it is. How likely is it for a parent to win a case, student to win a case, when it is only at the manifestation determination that they claim their child has a disability? Does that matter?
No, I don't think it does. I think if you can substantiate the disability, it doesn't matter. I mean, if you're going in your Hail Mary pass, like, hey, I think my kid has a disability, you need to do this, yeah. But if I'm coming in with an evaluation and test results to say, look, this kid clearly has this problem, then it works.
Okay.
And I think it works, if I can just keep talking some more.
Yeah,
the
go ahead.
It works is because now I'm saying, not only are you inappropriately going to discipline my child, I think we have a child find issue. There's a law that every district is supposed to identify students with disabilities and evaluate them in all areas of suspected disability, because part of my phone call to the lawyer is probably, and by the way, I might have a child find issue. Once we get this discipline thing all tied up, I'm going to want to call a child study team meeting, and I want him referred, and I want an eligibility meeting. I think I'm going to need an IEP, certainly at least a 504. So, they know, okay, we're serious. There is an identified disability. There are things, it's impacting his or her ability to receive an education, and we have to go in that direction too. So it's all about being able to prove your facts. And again, it's all about trying to help the kid, and I'll say to the lawyer, look, I'm not just trying to get him out of a suspension. I'm looking down the road, like, what are we going to do to help this kid? Clearly he hasn't been learning. He's a discipline problem because guess what? He can't read. He's dyslexic. He's acting out because he wants to get kicked out of the classroom, because he doesn't want to have to read from the board, because he can't read from the board. So, yeah.
Okay. I can think of situations with someone with Tourette, for example, where the parents may or it could be another type of neurological thing. The parent doesn't want to say anything in school. They don't want to call attention, don't want the kid to have any kind of stigma about having whatever this is. So they just try and manage the situation without having to declare the disability. And then all of a sudden, you've got a situation where they are either the bully or the victim, and then it comes out, but it just comes out in the worst possible way, it would seem to me.
Yeah, and I can see that, where they're going to say, oh, sure, your kid has Tourette's. Your kid meant to say that. Your kid doesn't have Tourette's. Well, now we need to have a serious conversation. And we can talk about, privacy and, what happens at the manifestation determination hearing doesn't become public information. I mean, what would go in the report is the act was determined to be a manifestation of the student's disability, but doesn't say what the disability is. So we would do what we could to protect the student's privacy.
Okay. Is there a link with HIB and violence from victims with disability? Actually, it's a two-part question. So first, is there a link with HIB and violence from victims with disabilities? Do you see that?
Is there a link between?
Is there a link with HIB and violence from victims with disabilities?
From victims with disabilities. Violence from victims with disabilities?
Yes, that's what the question is. Violence from victims with disabilities. And maybe we need some clarification here. Okay, let's skip that part. But then I'll ask the second part though. So what happens if the victim becomes the aggressor?
Oh, like somebody defending themselves, for example.
Yeah, you could say, but there's another question we have here too about this kid being picked on by another student, and the dad wants to resolve this by having the son learn how to box. And he thinks nothing will get resolved if the son does not stand up for himself. So it kind of falls into that same kind of category of learning the skills then to defend yourself.
Right.
So what if the victim becomes the aggressor?
Well, that's not HIB. That's going to be, whatever the legal term for he started it is. But,
okay.
It's more just, that's pure conflict. If this kid has been picked on, because rarely does the victim defend him or herself the first time. Like it's going to be more likely this kid's been picked on over a period of time, whether it's a week, a school year, all of middle school, and finally can't take it anymore, got the boxing lessons and said, you know what, I've had enough, I'm done. That student will probably be disciplined for physically harming the other student. I don't think the student will be suspended for something like that. That's the kind of thing we're like, all right, we got to punish you, but how about you have to feed like the rats in the lab? Generally, I mean, just again, this is not my legal advice. This was not my proudest parenting moment, but my kid was picked on in middle school. And I told him, my grandmother always told me, if somebody hits you, you hit them back harder and they'll never hit you again. So this kid was picking on my son, and I said to him, like, dude, like, you can't, if he gets physical with you, it's okay. I'm telling you, it's okay. You're going to get in trouble, but it's okay. You can hit him back, which, again, not my proudest parenting moment. And I went to the vice principal and I told him, look, just so you know, this is what I told my kid. If there's a problem, and he says, my mother told me to, I did. It never happened. It never came to blows, but whatever. I agree with that father out there that sometimes you want your kid just to be able to protect themselves. Violence not being the answer, and I know that. And you have to just be prepared that your kid may get disciplined too, but you got to pick your poison. And if I don't know. Yes, they will get disciplined. It will not be an HIB. I don't think it will be an HIB though.
Okay.
Power balance.
So we've gone a little over. I'm going to do one more, and so overall, okay. So this is a general advice question. Overall, what advice would you give to parents who find their child involved in an HIB incident, either as an aggressor or a victim?
As the aggressor, I want to know what happened. I want to see the report. I want to go through it carefully with my child to say, you know, like, did this happen? Did that happen? Who else was there? I want to make sure that everybody who was there got interviewed, had a statement made. I want to know the backstory. I want to know, again, if I'm the mother of the aggressor, I want to know, has this person ever picked on you? Why did you do it? Because there's always a reason you did something. You know, I want the whole picture so that I can try to make my kid look as the least guilty possible. If I'm the mother of the victim, I want all of the same information. I want to know the backstory. I want to know, has this happened before? Did anybody in school know that it's happened before? Like, does your guidance counselor know? Does your teacher know? Does the aide know? Because I want to be able to say to the school, you could have stopped this from happening. You know, you didn't prevent this. You know, maybe I want to know what the history between the kids is also.
Mm-hmm. And I guess in the big picture too is to kind of, you know, for me anyway, as a parent, maybe in this situation, is to take a breath and deal with it logically, you know, and not fly off the handle, because
right. I mean,
it, you know, it only complicates it when your kid's in this situation.
Right, and they're going to go out in the world where there are mean people, and they will work for some of the mean people. They will work with some of the mean people, and at the end of the day, they need to learn how to coexist with them, which is why hitting them is not the answer, which is why that was not my legal advice and was terrible parenting advice.
Okay, well, I think we'll end it on that. And we know what, as parents, I think we can all look and say, oh gosh, I wish I had done that differently, but it's, you know, that's why I've always maintained kids cannot second guess their parents. You do what you think is the right thing at the time, and you just can't have your kids, you know, coming back at you years later about, you know, why you did it a certain way.
Right, just know what the consequences are going to be.
Yep. All right. Beth, thank you so much. That was a lot of great information. I really appreciate your time tonight, and I'm going to give this back over to Kelly to kind of wrap things up.
Thank you for joining our webinar on harassment, intimidation, and bullying law. There is an exit survey which we need everyone attending to fill out. The webinar blog is now open and available for the next 7 days on the NJCTS website. For any additional questions that were not covered in tonight's presentation, that website is www.njcts.org. Also, an archived recording of tonight's webinar will be posted to the website shortly. Our next presentation, IDEA and 504 plans, what every parent should know, will be presented by Stacy Greenwald and is scheduled for November 13th, 2019. This ends tonight's webinar. Thank you, Ms. Manes, for your presentation, and thank you for everyone attending. Good night.